No, I think the development today is welcomed. It's welcomed on various counts. One, the ED itself comes to court and says, the lawyer for the ED comes and makes a fair statement that, look, we are ready to make a concession here. Please grant this person bail. So therefore, the court has not had an opportunity to hear the merits of the case and make any finding on the merits of the case. One. Second, the court also clarifies that this cannot be treated as a precedent, because do remember that in this case, there are a large number of very famous personalities who are in judicial custody as on today. So therefore, what happens today cannot be treated as a precedent by other persons, whether they are private individuals or public personalities who are in prison at the moment trying to get a bail. So therefore, while it is welcome that the ED has made a concession, I think it is not it's not a very clear precedent which can be used by other accused to argue, because Sanjay Singh has got bail, they should also be entitled bail. But Rajdeep, the larger question here is, and the more important question here is the law on bail when it comes to an ED offense. Why is bail, as you started the show, why is it becoming such a big thing or so difficult to get a bail? Please remember that the ED Act, the PMLA Act, which came into force, had a very rigorous condition for bail. It said that anybody who's been taken into judicial custody or has been arrested by the ED has to convince a court of law that that person has actually not committed the offense to try and get the bail. Now, this what is called a twin condition restriction is so draconian that how can someone who wants to get bail try to convince the court that, look, I have done nothing at such an early stage of the proceedings, so that the court is convinced to grant that person bail. So people languish for months in jail, because it is very difficult for any accused to come out of there and say that, look, please be convinced that I have not committed the offense. If that accused can convince the court that I have actually not committed the offense, then he can actually get acquitted.
So and presumably, Abhimanyu, these amendments were brought in 2018 through a money bill. So they went through the Rajya Sabha and the Supreme Court ratified it in 2022. But you're saying the basic premise of Section 45 of the PMLA is against our jurisprudence, which says bail, not jail. This has completely reversed the proof. Am I correct?
Yes, correct. But Rajdeep, what is more important is Supreme Court struck down this Section 45. Supreme Court came heavily down in a judgment called Nikesh Tara Chand of Justice Honorable Justice Nariman and Justice Kaul, saying that this condition that you have to satisfy the court that you've committed no offense, this condition is not correct, and it is not in sync with our constitutional and fundamental right to liberty, and therefore struck it down. But what happened after that was that a larger bench of Supreme Court, 3 judges of Supreme Court in Vijay Madan Lal Chaudhary, said that the act was again amended and a new provision brought in, and therefore that judgment was held not to be good law anymore. And in that way, those twin conditions again got revived back.
Right.
And matter is now pending before a review bench, because notice has been issued in open court and review will be heard, I think, sometime in July. So therefore, Rajdeep, the big picture is that Supreme Court had once upon a time actually struck down this condition. And if that judgment continued, people would get bail quite easily, just like they get bail in Prevention of Corruption Act offenses, or they get bail in cheating offenses or any other economic offenses. There is no need to have these twin conditions in the PMLA, because do remember that PMLA is a 7-year offense, which is just like any other offense in the IPC, whether it is cheating, whether it is some of those Prevention of Corruption Act offenses. So therefore, to have such a draconian condition where a person is told that you have to convince the court that you've committed no offense cannot, in today's time, according to me, be stand in a statute book.
I take your point and very strong words from you, Abhimanyu. But then what explains, Bishwajit Bhattacharya, the kind of U-turn the ED suddenly makes in court today, saying we are not opposing it? Is it because the ED feared that if they opposed it, it would go on the merits of the case, wherein the merits of the case would suggest, as per the Supreme Court, that you haven't found a money trail linking it to Sanjay Singh yet?
ED knows very well, as Justice Khanna of the Supreme Court observed, that no statute can override constitutional rights. Section 45 is a statute. It says, notwithstanding whatever has been contained in Code of Civil Procedure Code, It cannot and does not say notwithstanding the Constitution of India. So I find this entire debate of Section 45 being draconian and the constitutional courts are fettered in their hands and they cannot grant bail. I mean, if I may use a very strong word, which I should not, is utter nonsense. Rajdeep, with the greatest of respect, I submit before your distinguished viewers that even before Section 45 of the PMLA Act, which talks about the reverse, presumption of guilt, in the repealed Foreign Exchange Regulation Act of 1973, there were two sections, Section 59 and Section 71. There was reverse presumption. So this is nothing new. So I am very, very utterly surprised and shocked. The entire nation has been debating about Section 45. It is not a big deal.
No, so are you saying that the Supreme Court or indeed any court still has a lot of leeway to grant personal liberty to a citizen who's accused for under PMLA? Because look at the track record, barring a few cases. That's why Sanjay Singh is an exception. The fact is, as Abhimanyu pointed out, generally people are spending 6 months a year, even more. Look at even the case of Manish Sisodia. Look at how much time he spent in jail.
It's wrong. It's wrong. I say 100 times Manish Sisodia being incarcerated without a shred and iota of evidence for more than a year is utterly wrong. Rajdeep, I want to make it very clear to your audience. Kindly, I have already stated, I am reiterating. Constitutional courts cannot be bound by statutes. That the fundamental law, which the law students first and the entire lawyers fraternity and judiciary must appreciate. Section 45 cannot stand in the way of granting bail.
Okay, you made that point and you're making it emphatically.
One more thing, Rajdeep, yes. May I just say?
Yes.
And, fundamental right and human right under Part 3 of the Constitution and also Article 20, Subclause 3 of the Constitution, you arrest a person and you say he is not cooperating because you are expecting him to answer so that without any investigation, he straight away records your statement. I am sorry. No accused can be expected to toe the lines of any prosecution to prove the case of the prosecution. So I find, with the greatest of respect,
right,
and may I also say on 22nd of September, 1998, I had contributed as a witness in the Parliamentary Standing Committee of Finance chaired by the late Murli Devra, when 50 members of parliaments were there, all the political parties were there. We were 3 witnesses. I was fielded by Confederation of Indian Industry. I spoke throughout the day. I kept on answering. Myself, late J.B. Dadachandji and Mr. Ashwani Kumar. So the intention of Parliament was bifurcated Foreign Exchange Regulation Act into two. One to Foreign Exchange Management Act, which is not criminal, and Prevention of Money Laundering Act. Now you are going on expanding the schedule offenses, like even the prostitution, like the Prevention of Immoral Traffic Act can also be deemed to be money laundering. What a ridiculous state of affairs is this.
I take your point, Vishwajit Bhattacharya. I just want to bring in, though, Abhimanyu, for one final word, Abhimanyu, on what does what happened today mean for Arvind Kejriwal? Because as you said, the court made it very clear, this is not a precedent, these are peculiar circumstances. But the fact is, in some way, this is also seen as a conspiracy case. And therefore, if one person gets bail, does it make it easier for the others? Or are they all to be treated as separate cases, given the fact that the ED now claims that Mr. Kejriwal is the mastermind?
Rajdeep, according to me, what has happened today will not come to the rescue of any other accused, whether it is Mr. Kejriwal or Mr. Sisodia. They would have to stand on their own feet and they would have to argue and show to the court that there is a case here they've made out which shows that there is no reasonable prospect of any conviction and that they satisfy the twin conditions. I don't think so. The fact that Sanjay Singh has got the bail will in any way help Arvind Kejriwal's legal argument or Manish Sisodia's legal argument. They'll have to go to court and convince why they should be granted bail, and they will have to satisfy the rigors of Section 45 and the twin conditions that are contained there. Yes, of course, politically, and, the perception now would be that, look, because ED has conceded on Sanjay Singh, maybe the environment is that others would also try and make out a case that if one person is out, we should also be out. But Rajdeep, having been practicing as a PMLA lawyer for many years now, and knowing this, I don't think so that this can be treated as a precedent. Rather, if I'm not mistaken, the order very clearly says that this case cannot be treated as a precedent by other accused in this same right. ECIR.
And in fact, we've got a flash which says that the Supreme Court has now removed the statement from the order where it said Sanjay Singh can participate in political activities. So we will wait to see how those conditions of bail also operate. But for now, Bishwajit Bhattacharya and Abhimanyu Bhandari for giving us a sense of PMLA, its implications and how bail works in PMLA. Thank you so much for joining me here at the top of the news today. Our two stalwart lawyers to looking at the politics that's playing out, because all of this is taking place, remember, against the backdrop of the Lok Sabha elections and indeed the fear that the opposition has that there is no level playing field. Today, Aam Aadmi Party leader Atishi claimed she was approached by the BJP through mediators to leave the Aam Aadmi Party, failing which she too would be arrested. The BJP has rubbished the charge and said the AAP is getting desperate. Listen in.
मुझे ये कहा गया कि या तो मैं भारतीय जनता पार्टी ज्वाइन कर लूं, अपना पॉलिटिकल करियर बचा लूं, अपना पॉलिटिकल करियर बढ़ा लूं, और अगर भारतीय जनता पार्टी नहीं ज्वाइन करी तो आने वाले 1 महीने में ईडी द्वारा मुझे गिरफ्तार कर लिया जाएगा। ये एक मेरे बहुत करीबी व्यक्ति के माध्यम से मुझे बताया गया।
हमारे यहाँ आतिशी जैसे पॉलिटिकल एक्टिविस्ट के लिए कोई वैकेंसी है नहीं। जब शराब घोटाले में सारी आम आदमी पार्टी फंसी हुई है, तो हम इस समय उनको अपने यहाँ लेके हमने क्या अपने लिए सिरदर्दी क्रिएट करनी है?
So what explains the politics that's playing out? First, of course, the ED's U-turn in the Sanjay Singh case. What implications will it have politically? Is it a silver lining for the Aam Aadmi Party ahead of the Lok Sabha elections? Will Sanjay Singh lead the AAP campaign? Will bail blunt the AAP's vendetta charge? How does this all play out now politically? Joining me now are two other special guests, Nalin Kohli, BJP spokesperson and senior Supreme Court lawyer, and Jasmine Shah, Aam Aadmi Party spokesperson, is joining me. To you, Nalin Kohli, first. The bail which has been granted to Sanjay Singh is being seen by some as a silver lining for Aam Aadmi Party ahead of the Lok Sabha elections, particularly the observation that no money trail or no money has been found on Sanjay Singh. How do you see it?
I am amazed, and as a lawyer I must point this out, at how this can be a cause of celebration when Sanjay Singh stands charge sheeted, is going to be tried for money laundering, and the trial court has already taken cognizance of the charge sheet filed by the Enforcement Directorate. It's amazing that somebody who gets bail is celebrating it while he has to face the entire trial to prove his innocence. Taking cognizance means that the court has prima facie agreed with the charge sheet and seen material on record that points to Mr. Sanjay Singh being involved in this money laundering issue. Point 2. How is the bail taken to be a U-turn by the Enforcement Directorate? The ED, through its counsel, the learned ASG, Mr. Raju, did not oppose the bail. The court says it won't be a precedent. The court says we are not commenting on the merits. Bail does not change the fact that Mr. Sanjay Singh is an accused in the charge sheet filed, which the court has accepted and taken cognizance and directed him to now face trial.
Right.
So therefore, if this is a cause of celebration for the Aam Aadmi Party, then their standards of honesty are really amazing.
Can I get Jasmine Shah to respond? Jasmine Shah, why is the Aam Aadmi Party celebrating? It's only bail. It's not as if Sanjay Singh has been declared innocent. So why is the celebration over a bail? Is it premature in many ways?
Rajdeep, first let me correct you. We're not celebrating, but we are recognizing that this is not just a huge legal victory, but this is a huge moral victory for the entire Aam Aadmi Party. Why? Because today in the bail hearing, what the honorable justices of the Supreme Court said has a lot of meaning. They said, if for 6 months you have put some person in jail, and after 6 months you are saying you have no money trail, you have no trace, which means you have no proof, then why are you putting somebody in behind bars? And this is precisely what Aam Aadmi Party has been saying so far. We have said that this is the first time that for over 2 years an investigation is going on. Not a single evidence has been found. Not a single penny of money trail has been found. All that the BJP and ED are presenting are, fake statements by government approvers or witnesses who we all know under what pressure and duress these statements were extracted. And today the court seems to have agreed with it. So on one side, the court is saying no money trail is found. Second, and this is very important.
No money trail in Sanjay Singh's case. No, Mr. Jasmine Shah, let's be correct. No money trail in the specific instance of Sanjay Singh.
No, the larger point that not a single rupee of money trail has been found anywhere in this case is also true. And this is a matter of fact. Even when Mr. Sisodia's bail hearing was happening, this is a matter that, the Supreme Court, even at that point, they made that if this is the evidence with which you will go to trial, this case will stand dismissed in 2 minutes. And you are aware about this remark being made back in October. Today, we are in the month of April, and the same remark continues. The other important thing I want to point out is that this entire case, as far as Mr. Sanjay Singh was concerned, was made out on the statement of only one approver called Dinesh Arora. Now, for the first 10 statements that this approver gives, he sings a very different tune. He never names Mr. Sanjay Singh.
In the first 9 statements.
No, the data I have is that the first 10 statements.
First 9 statements.
Okay,
I've got the Supreme Court
9
order.
statements. All right. So first 9 statements, he's saying that I have nothing to do with Sanjay Singh. He never names him, but then he's arrested. He's incarcerated. And finally, the 10th statement comes out where he suddenly names Sanjay Singh. He has no corroborating evidence. And on the basis of that 1/10th statement, first the ED junks the other 9 statements. And now it's saying that on 10th statement, I'll put a parliamentarian inside jail.
Okay.
So this is the entire joke that is being going out in the name of a liquor scam investigation. We stand vindicated today. Why? Not because, it's just a bail. Because so far, BJP has been saying, okay, you have a lot of arguments to make. You are saying Sarath Reddy has given us BJP, a lot of crores of money, who's another star witness. Then why are you guys not getting bail? Even the Prime Minister a day back said कि बड़े-बड़े भ्रष्टाचारी को Supreme Court से भी bail नहीं मिल रही है. अब bail मिल गई. That entirely shows that, all this while what Aam Aadmi Party has been saying, and this is the same truth that holds for Mr. Kejriwal. He has also been framed only and only on the basis of these fake statements by people who were earlier singing a different tune. You put them in jail for 6 months and then they say what the ED wants them to say. And this is the entire game that is being called out by the Supreme Court today. And I think this completely changes, I would say, the trajectory of where this case is going. It's a huge moral victory. It's a huge legal victory for the Aam Aadmi Party.
Okay, Nalin Kohli, your turn now.
I need to respond.
Yes, please.
I have to respond. This will take time. And I must also point out, Rajdeep, that this is not a joke, as Mr. Shah is trying to make it. There's a bundle of falsehood that has come from his side. Let me correct the facts. First of all, for anyone who understands